Hello there. I'm Victor Manibo, one of the lawyers at Wang Law Office. I'm an immigration attorney, and today you're watching the second episode of one of our weekly shows. This is our newest YouTube show, and it's called The AM Show.
Hi, I'm the host Ariel. I'm also a senior paralegal in Wang Law Office. Our show going to start every Friday at 8 a.m. EST and 11 a.m. PST.
And in case you weren't here last time, the format for this show is a question and answer type format where we're taking questions from our viewers and from prospective clients and our current clients about immigration topics. If you have any questions about immigration that pop into your head, feel free to write us on YouTube on the comment section, or you can also reach out to us directly via email, and we'll try to answer them in a particular episode that talks about that topic.
Yeah, Victor, can you introduce yourself a little bit?
Yeah, sure. Like I said, am an immigration attorney with Wang Law Office. I've been an attorney for this firm for about 10 years, and that's also about the same time that I've been an attorney. I graduated from Cardozo. I know, 10 years, that's a long time. Or feels like a long time to me.
Yeah.
I graduated from Cardozo School of Law here in New York City, and I specialize in immigration and civil rights cases and some criminal law cases as far as they impact immigration.
Yeah, last time we talked about I-130 petition, right?
Mhm.
This week, we're going to discuss about family-based green card. First, what is family-based green card?
Right. So last week we talked about I-130 petitions, or petitions for alien relatives, meaning it's the process by which a U.S. citizen or someone who has a green card can petition for family members so that they can have status in the U.S. Today we're going to talk about green cards or adjustment of status or family-based green cards. That is a status that is a valid immigration status. And the technical term is lawful permanent resident, meaning someone with a green card is an LPR, a lawful permanent resident. And one of the ways that you can get this status is through a family petition. That's why it's connected to the I-130. If you are a U.S. citizen or a lawful permanent resident, you can petition for another family member so that they can be an LPR.
So LPR equal to green card, right?
Yes. Green card is a very, that's how we usually talk about it, because in the old days, the card is actually green in color. But the technical term is lawful permanent resident. And that's what we're going to be talking about today. Like, how do you become a lawful permanent resident through your family?
So you mentioned AOS earlier.
Right.
You're going to be eligible for AOS.
So AOS is a common immigration term that people might have heard of before. AOS means adjustment of status. So we'll talk about that one by one, right? Adjustment, that means like it's a change, right? And the word adjustment means change. Status, when we talk of status in the immigration field, it means immigration status. What kind of benefit did you get from our immigration agencies that allows you to stay in the country? So AOS, or adjustment of status, means it's a process by which someone who already has status in the U.S., who is present in the U.S., already has status, how they can adjust or change their status. Now, the next question is, what are you adjusting to? What are you changing to, right? So what you're changing to is to an LPR. Basically, you're adjusting your current status, whatever that is, to that of an LPR so that you can get a green card. And to go back to your question, if you need to adjust status so that you can be an LPR, that means first you have to be physically present in the United States. You're already here in the country, you already have status, meaning you entered and you were given status by our immigration agencies to stay here legally. And then you go through the application to adjust from that old status to LPR status.
So if you are not in the country, you cannot go to this AOS stage, right?
Right. You can still get a green card or LPR status if you're not within the US, but it's a different process. It's called immigrant visa processing or consular processing. So you make your application at the consulate outside of the US. Now, AOS that we were talking about, that we'll be talking about for most of the show, means adjusting from a status where you already have the status and you're already in the country.
So you mentioned that I need to enter with a visa, right? If I enter without a visa, am I still able to AOS?
Generally, if you entered the country without a visa, or if you enter the country illegally, you might be ineligible for AOS, or your process will be a little bit more complicated because an illegal entry into the US means you have unlawful presence, meaning you were unlawfully present in the US. There are some exceptions to that. Like if you're an immediate relative, you don't have to worry about unlawful presence. And we'll talk about immediate relatives later on. But the short answer to this question is it depends. Some people who, yeah, I know, it depends. Some people who enter the country without a visa might not be eligible for AOS. Some people who entered the country without a visa might be eligible for an AOS, but might require a waiver, which is a separate application. And some people who entered the US illegally might still be eligible for AOS, even though they entered illegally, even without a waiver.
Okay. So you talk about people can do it, right? How about who cannot AOS?
Okay, so in general, our immigration laws are strict with certain things where they don't provide LPR status, or they don't allow adjustment of status for certain individuals. For example, if you're not in the US, obviously you cannot adjust status because you have to go through a different process. Like I was saying earlier, the process is called immigrant visa processing or consular processing. You have to do everything outside of the country through our consulates and embassies overseas. If you are present in the United States, you can't get a green card, you can't adjust status. In general, also, there are other types of people who will not get a green card, regardless of it, they're doing it outside through immigrant processing or through adjustment of status or AOS. If you have convictions for certain crimes, either state or federal, depending on how serious those crimes are, you won't get a green card. If you have a communicable disease, you probably will be ineligible for a green card. Right now, this doesn't necessarily include COVID. COVID is under like very specific rules, so it's not like if you have COVID now, you're not going to get a green card. There are certain types of more serious diseases. Not that COVID is not serious, obviously it's very serious, but there are certain diseases which can bar you from getting a green card through AOS or through consular processing. If you've broken immigration laws in the past, like you've gotten a removal order, or you used fake documentation for immigration, or you engaged in a fake marriage, that can completely make you ineligible for any benefit, not just a green card or not just adjustment of status.
That's serious.
Yeah. I mean, there are a lot more categories, but those are the common ones that people might have heard about or might have questions about.
Yeah, back to our today's topic. Is there different types of family-based green cards?
Right. So family-based green card or family-based adjustment of status. Again, this is for U.S. citizens or lawful permanent residents petitioning for their relatives who don't have status yet so that they can get a green card. In terms of different types, there's two broad types or methods of adjusting status. One is the immediate relatives, and the other is family preference categories. And these two groups have different advantages or different requirements, but the basic definition is immediate relative family-based green cards are those that involve close family relationships. And what do I mean by that? I mean, if you're a US citizen or an LPR petitioning for your parent, if you're petitioning for your child, or if you're petitioning for your spouse. Those are the immediate relatives. And the other group is family preference. These are still family relationships, but they're not as close as up and down and beside, you know? So these will include siblings, and these are the family preference categories are the categories for someone who is an LPR. Immediate relatives, that's all for US citizen.
So who belong to this IR immediate relative?
Yeah, IR or immediate relatives. Like I mentioned earlier, there are a limited number of relationships. If you are a US citizen and you're applying for your parent, that's an immediate relative. US citizen applying for their spouse, that's an immediate relative. A US citizen applying for their child under 21 years of age. So a child under 21 years of age and a child who is unmarried. That's also an immediate relative. So if you're a US citizen and you have a child who's 18 but married, that's not an immediate relative anymore because they're married. But if the child is under 21 and unmarried, then that's an immediate relative. And the other category is orphan adoptions. So if a US citizen adopts an orphan, either adopting the orphan within the United States or outside of the United States, that is also an immediate relative.
So is there any advantage for this IR category?
The advantage for immediate relatives is basically speed. And this is why. With an immediate relative, you don't have to wait in line to get basically to get a turn to apply for a green card. If you are an immediate relative and you are able to establish that you are an immediate relative, you can apply for a green card right away. Now, the preference category, the other group of adjustment of status that I was talking about earlier, they have to wait in line, and sometimes the line is long. So maybe some of our viewers have heard that, you know, their I-130, their petitions for their relatives have been pending a long time and they still can't get a green card. And that's the reason why, because for preference categories, you have to wait in line. You have to wait your turn before you can apply for a green card.
What kind of people belong to this preference category?
Okay, so last week we talked about I-130 relationships, right? It involves US citizens, it involves LPRs. So all the petitions made by LPRs is under the family preference category. That's one. And then the other is the siblings of US citizens. That's a family preference category. And the other is adult sons and daughters, adult children of US citizens. So for example, you're a US citizen and you have a child, but that child is over 21. That relationship is going to be a family preference relationship. It's not going to be an immediate relative relationship. Same way with if you're a US citizen and you have a child, but they're married, that's going to be a preference category as well. And again, the disadvantage of family preference categories is that you have to wait in line to get your turn so that you can apply for a green card. If you're an immediate relative, you can just do it right away. And, you know, we can talk about that more later on how the process actually happens.
So you mentioned that they cannot or they can AOS right away.
Yeah.
So you're going to have some difference between the IR and the family preference.
Right. So yeah, that's the main difference is you have to wait in line. And the reason why you have to wait in line is because for preference categories, right? The petitions by LPRs or US citizen petitions for their siblings or their adult children, those kinds of relationships, those kinds of categories have a numerical limitation. The US only allows for green cards for a certain number of those categories. And as you can imagine, there are a lot of people who are petitioning, who are applying, for good reason, right? You want your family to be with you in the United States. And because of the volume of applications in these preference categories, there is sometimes a long wait time. And that's what's called priority date. And we can talk about that a little bit more.
You mentioned priority date. What is that?
The priority date is, so when you apply for a petition, when you petition a relative under one of the preference categories, the priority date is the date that, the priority date is what immigration uses to determine the petition's place in line. Like imagine if you're in the bank and you're waiting in line, but it's an imaginary bank because like we're not all physically waiting in line in immigration. The way that the applications are sorted is through priority date. Obviously, the earlier the priority date is, the closer you are to being adjudicated and served and, basically getting to the front of the bank teller. That the earlier priority date is.
Similar to you getting a lumber and holding the lumber.
Exactly. But in this case, the number is a date, a specific date. And that date usually coincides with when the I-130 was filed. And so if the US citizen or the LPR has filed an I-130, they will get an I-797 notice of action or a receipt notice. And that receipt notice will indicate the priority date.
Back to our topic, how do I apply for adjustment of status in the US?
So adjustment of status, going back, we have to understand what the concept is. Adjustment of status means you're adjusting from one status to another. You already have status, you're changing to LPR, right? And to do that, you have to file an application with a US Citizenship and Immigration Service, or USCIS, and the application form is called the Form I-485. It's called Application to Register Permanent Residence or Adjust Status. The form itself is very complicated. It's got a lot of questions that, if you are unfamiliar, if you're not a lawyer or if you're not trained at this, it's not something that I would advise anyone to fill out on their own. I mean, I think it's like a 20-page form and it asks for a lot of information. So yeah, but that is the form to use.
So you mentioned I-130 earlier. Now you mentioned I-485. So can I file this I-130 and I-485 together, or I need to file the I-485 after the I-130?
Okay. So, last week we talked about the I-130 a lot and how the I-130 is not a form of status. It just establishes the family relationship, right? And now, sometimes in certain cases, you can file the I-130 to establish the family relationship, and you can file the 485 to get the status. You can file them at the same time. Both of those forms, the I-130 and the I-485 at the same time, can be filed, and that's called concurrent filing. So two forms, I-130 and 485, filed together. Now, that can only be done for immediate relatives. And the reason is because immediate relatives don't have to wait in line. Like if the I-130 is approved, if it's established that you are the spouse of a US citizen or you're the parent of a US citizen, you don't have to wait in line. Like you don't have to wait for your priority date to be served, and you can apply for adjustment of status right away. So you can file the I-485 right away. So USCIS allows immediate relatives to file the I-130 and I-485 at the same time. Now, if you are a preference category, your petition is done by an LPR, or you're done by a U.S. citizen for a sibling or an adult child or a married child, you cannot do concurrent filing because you have to wait in line. So you have to wait for the I-130 to be approved. That's one, which could take, years sometimes. We talked about it last week. Sometimes it could take years. And then you have to wait your turn in line. You have to wait for your priority date to be current. Current means it's your turn, you're allowed to apply for adjustment of status. And waiting for your turn in line, waiting for your priority date to be current, also could take years. So you have to do those two things first. Get the I-130 approved, and then get your priority date current, and then you can apply for I-485. So for preference categories, you cannot do concurrent filing. You have to wait for the I-130 and the priority date before filing your I-485.
So what kind of document I need to submit for this I-485 adjustment of status package?
So for the I-485, as I was saying earlier, it's a very complicated form that asks for a lot of information. But at the same time, it's not just the form that you have to submit. Like, you have to submit a lot of other things. The purpose of the I-485 is to show that you have status in the country so that you can adjust to LPR, right? The purpose is also to see that you entered lawfully in the United States, that you are not disqualified by, criminal issues or terrorist activities or immigration fraud. And the other purpose is also to establish that you have an approved I-130 or you have an immediate relative relationship. And you're proving a lot of things to prove to USCIS that you should get a green card, and a form is not enough. You have to submit supporting documents. And the typical supporting documents for an I-485 include your birth certificate to show who you are, your passport to show how you entered, and to show what kind of visa or what kind of status you have. You also need to submit documents establishing the relationship to the petitioner if your I-130 isn't approved yet and you're doing concurrent filing. You also, as with any USCIS form, you have to submit fees. You have to pay for it. It's not cheap. It's $1,225. You have to submit your passport photos and a couple of other things, such as an I-693, which is a different form. It's a medical exam that is done by a doctor who can certify that you don't have any communicable diseases. Remember, we talked about earlier
This can cause you cannot AOS.
Right, exactly. So a doctor has to examine you and fill out a form I-693 and say, basically, yes, this person does not have any kind of disease that disqualify them from applying for a green card or from being an LPR. And another common additional form that you have to file with your I-485 is a form I-864, or an affidavit of support. This is a big topic, and it's a little more complicated to discuss, but I'm going to just talk about it a little bit here. An affidavit of support is proof that the person who is about to get a green card, or the person who is applying for a green card, is not going to be a public charge, or is not going to be a strain on the government, or would not require too much assistance or too much benefits from the government. So the I-864 requires someone applying for an I-485 to have a petitioner or a sponsor say that I have enough income, I have enough assets that I can support this person who's applying for a green card until a certain period of time during which hopefully there will not be too much strain on the government. Because as you know, someone who is just new to the country probably isn't making a lot of money to support themselves immediately. Some of them do, but a lot of them don't. So the government requires a sponsor or the petitioner to fill out an affidavit of support saying, I will support this person.
So we are going to get a work permit after I apply this adjustment of status?
Okay, so that's a good question, because that's kind of related to what we were talking about, right? some people, when they come to the United States, they don't really necessarily have a means of making a living, and they need a sponsor for the I-864 form. But you know, while the I-45 is pending, say you filed your application form, you filed the fees, you filed all the supporting documents, while it's pending, you may be able to get an employment authorization document, an EAD or an EAD card, which will allow you to work legally in the United States while your adjustment of status application is pending. Which is great, because sometimes these I-485s, they take a really long time to be approved. And, you know, when you're waiting here for 1 year, 2 years, and you can't work, that's got to be difficult. Even if you have relatives who are sponsoring you, it's still difficult. So you can apply for an EAD or a work permit after you receive your I-485 receipt notice saying that you do have an I-485 pending, or even concurrently with the I-485, you can file an application for an EAD. And the application is a separate form. It's called an I-765. And you can submit that with your I-485, basically saying to USCIS, I'm applying for a green card. Also, while it's pending, can you give me an EAD card so I can work while I wait?
So get into a similar question. Can I travel outside to the US after apply this adjustment of status?
Well, yes, it depends, but generally, yes. Let's say you are applying for a green card, it's taking a long time, maybe 1 or 2 years, and you have to leave the country for certain reasons. You could file what's called an advanced parole document. And what that does is it allows you to leave the country and come back without it being a problem on your adjustment of status application, or without it being a problem on your return to the country. Because generally, if you're adjusting status and if you leave the country, your application is done. And they're probably not going to let you back in, especially if you don't have status anymore. Maybe your previous status expired while your adjustment of status application is pending, so you're not going to be able to come back. Now, the way to avoid that is to apply for advanced parole. You file another form for that. It's called the Form I-131. And what that does, if it's approved, is it allows you to leave and come back with no problems at entry and no problems with your adjustment of status application. However, you can't just say, oh, I want to go back to my home country because I need a vacation or because I miss my mom. You have to have certain reasons, and certain reasons are usually medical or humanitarian reasons. You have to go outside of the country to get medical treatment, or you have to go back to your home country because a parent recently passed away. Those kinds of reasons will probably enable you to get an advanced parole document to leave the country and come back. It's usually within a certain amount of time and for a really good reason.
So how can I check the status, the application status, the adjustment of status application?
So let's say you hired a lawyer to file the application. Hopefully you hired a lawyer, and now it's with USCIS. And then you get a notice from USCIS saying, okay, we received your I-485, it's pending. Sometimes you want to know what's going on with your case. You can check the status online. You can go to the USCIS website and enter the receipt number on your I-485, and it'll tell you what the status of your case is.
So do I have to leave my fingerprint with USCIS when I'm doing this family-based green card?
That's a good question, and the answer is yes. Green card or LPR status is very important because it gives someone a lot of benefits. Once you are an LPR, you get to stay in the country basically indefinitely. After a while, after 3 years or 5 years, you can become a U.S. citizen. As an LPR, you can work You can travel in and out of the country. You can travel to other countries as a U.S. lawful permanent resident quite easily, and you can participate in a lot of things. In certain places in the U.S., you might be able to vote in local elections. In certain parts of the U.S., you might be able to get healthcare, and in certain parts of the U.S., you might be able to get a driver's license. So, because it's such an important benefit, the U.S. is very strict about the identity of people who apply for adjustment of status. And so you do have to go through fingerprinting. They will take your photo. They will collect background information from you to make sure that you are who you are and there are no problems in your background. Like I was saying earlier, no links to terrorist activities, no criminal history, things like that.
Yeah, actually our time is up, and feel free to leave your question on any topic to us.
Yeah. Oh my God, that was so fast. I didn't even realize we're running out of time. We still have a lot of I've already got questions. We might do that in a separate episode. Maybe we'll do a part 2. But please always follow us. Our show again premieres on Friday mornings. You can write us on YouTube or email us for all of your questions about any topic, not just 485 or not just 130, but anything immigration related, and we're going to try and collect it and answer them. And hopefully my answers will be very helpful to you. I am a lawyer, but this show does not establish any attorney-client relationship with our viewers. And you shouldn't take this as direct legal advice. These are my opinions, my experience. Obviously, it's based on my experience in immigration and my training, but it doesn't qualify or constitute legal advice. Okay, it doesn't make me a lawyer just because you're watching me on YouTube. So just remember that. However, if you do want to become a client, or you're thinking about consulting with us to see if you want to have our firm possibly take your case and help you out with your immigration problems, please feel free to call us. Our contact information is on the YouTube.
Yeah, you can continue follow us on the YouTube. Thank you. See you next time.
Bye.